has turned from the legal or judicial one to a political case. Addressing journalists in Abuja, the lawyers say, despite all the illegality that surrounds the arrest and extradition of Nnamdi Kanu from Kenya and the futile efforts to use the court to nail him, his continued detention at the Department of State Security Services is not predicated on any court order but an illegal detention. The lawyers allege that there is a deliberate effort by the federal government and the judiciary not to hear and or determine Nnamdi Kanu's case and appeals on time.
The continued detention of Onyendu is illegal and without the backing of any court of law. It is noteworthy that Onyendu's continued detention at the Department of State Security Service is illegal and not predicated on any court order. Recall that Onyendu was remanded on the purported belief that he jumped bail. By the decision of the Court of Appeal, all the charges for which Onyendu is being tried were quashed for want of jurisdiction and the violation of the Extradition Act of both Kenya and Nigeria. It is not disputable that Nnamdi Kanu has the constitutional right to agitate for Biafra. Self-determination is recognized and sanctioned under our laws.
On the 24th day of September 2024, Justice Nyako of the Federal High Court Abuja made an order recusing herself from the case of terrorism leveled against Nnamdi Kanu before her court and sent the case file to the Chief Judge of the Federal High Court for reassignment to another judge of the court. It is getting to 5 months since the court made the order. There is no such reassignment by the Chief Judge to date. To the federal government of Nigeria, insofar as Nnamdi Kanu remains in DSS custody, trial can go to hell.
Recall that Nnamdi Kanu's case was commenced almost over 9 years ago when he was first arrested in Lagos. You can imagine what it means for someone to be on an endless trial that never really happens for almost 10 years and being detained without conviction for 18 months, initially from 2015 to 2017, and again for over 3.5 years from 2021 to the present.
The detention of Nnamdi Kanu has become unconstitutional by effluxion of time. By Aloy Ejimako. For the benefit of those who ask me, the truth is that Mazi Nnamdi Kanu properly exercised his constitutional right back September last year when he requested Justice Binta Murtala Nyako to recuse herself from presiding over his case. By any definition, it was an informed decision that is bereft of any personal animosity or any intransigence to the judicial order, even when it rankled some as brazen and gutsy. In particular, the action was propelled by a simmering loss of confidence in the judge, stemming from these key events. First, back in June 2021, the judge conducted a hearing by which Mazi Kanu, an awaiting trial, was ordered, remanded without notice to, and the presence of his former counsel of record at the hearing. That was a grave constitutional error that turned highly prejudicial against Mazi Kanu. Second, Mazi Kanu was ordered detained in DSS cell instead of a prison as the law requires, albeit with some exceptions. The excuse then, which, by the way, fell outside the exceptions, was that every penitentiary in Nigeria is porous or pathetically low security. This excuse suggested a judicial state of mind that imputed a proclivity for jailbreak to Mazi Kanu. That's wrong and presumptuous. Third, when the DSS detention posed grave risks to Mazi Kanu's constitutional right to fair hearing and to counsel, the judge summarily refused his application for transfer to prison or other less restrictive facility. That's manifest injustice. Fourth, when the Supreme Court ruled against Mazi Kanu's bail revocation, the same judge who had revoked his bail refused to reinstate the bail. That's an egregious violation of the Constitution and the doctrine of stare decisis. Fifth, the Supreme Court had held that, by revoking Mazi Kanu's bail, the judge's impartiality has become suspect. If you would like a partial judge to try your case, go ahead and take the chance, but keep in mind that it will amount to deadly hubris to ignore such a weighty censure from the apex court. And sixth, Despite the enormous risks to Mazi Kanu's right to fair hearing posed by the strict conditions of his detention at the DSS, the judge ordered an accelerated trial. That's the last straw that broke the camel's back. If you are wondering about the next steps, here it is. Given that the judge had affirmed the recusal in good faith and enrolled an order in that regard, the case will remain in limbo until another judge is assigned to handle it by the Chief Judge of the Federal High Court. That a new or another judge has not been assigned to the case, and such has lingered for an unreasonable period of time. A vigorous case can be made that the continued incarceration of Mazi Kanu has become unconstitutional by a fluxion of time. In plain terms, the Constitution forbids the authorities from detaining anybody without trial beyond a limited period of time. In this very case, that period time has come and passed. And this judicial gridlock is not the fault of Mazi Kanu. It's instead the fault of the authorities that have proved unable or unwilling to conduct Mazi Kanu's case in accordance with the dictates of the Constitution and the statutes pertinent to the case. And to make matters worse, the extraordinary rendition brought its own unique complications that have not settled to this day. Presently, there is no pathway for legally resuming the trial before Justice Binta Murtala Nyako, because her order of recusal remains extant and subsisting to boot. Thus, any step taken in violation of the order will trigger a rash of countervailing measures that will surely culminate in more significant legal complications. Bottom line, Mazi Nnamdi Kanu is never going back to Egypt. And the truth is, Nigerian government and her judiciary are deliberately delaying Nnamdi Kanu's trial. The legal team of Nnamdi Kanu, leader of the indigenous people of Biafra, IPOB, has raised an alarm over the non-resumption of the trial of the Biafra agitator. The lawyers accuse the federal government and the judiciary of deliberately delaying the resumption of Kanu's case in court. The legal team, consisting of lead counsel Aloy Ejimako, Jude Ugwanyi, and Nemeka Ejiofor, addressed the conference as part of efforts to mark the arrest of Kanu 9 years ago after he returned to Nigeria from London. Kanu was arrested and detained on trumped-up charges of treasonable felony, publication of defamatory matters, and improper importation of goods into Nigeria. While he was arraigned, the IPOB leader pleaded not guilty to the charges on 12 December 2017, but was remanded until 25 April 2017, when he was granted bail by Justice Binta Nyako of the Federal High Court in Abuja. Upon his release, soldiers of Operation Python Dance invaded Kanu's ancestral home in Afaraku, Abia State, between 10th and 14th of April 2017. The invasion led to Kanu fleeing Nigeria for London, where he continued his agitation for Biafra. His case came up before Justice Nyako of the Federal High Court in Abuja on 26 June 2018, but he was not in court, having exiled to Kenya to save his life. On 28 March-June 2019, the federal government of Nigeria informed the court that Kanu had jumped bail and violated the terms of his bail, thus applying for the revocation of his bail. Following this, an arrest warrant was issued for Kanu, along with an order forfeiting the bail bonds of his sureties. After the Federal High Court revoked Kanu's bail and issued a warrant for his arrest, the federal government of Nigeria abducted him from Nairobi, Kenya, to Nigeria. However, the legal team said the Nigerian government and judiciary are deliberately delaying the hearing of Kanu's case. In a joint statement, the lawyers based this claim on the fact that on 24 September 2024, Justice Binta Nyako of the Federal High Court, Abuja, made an order recusing herself from the terrorism case of Kanu before her court and sent the case file to the Chief Judge of the Federal High Court for reassignment to another judge. They lamented that the case has not been reassigned to another judge, almost 5 months after she recused herself. The lawyers also maintained that Kanu was justified in demanding the recusal of Justice Nyako from his case. The statement said, "There is a concerted effort by the federal government of Nigeria and the judiciary not to hear or determine Mazi Nnamdi Kanu's cases and appeals in a timely manner. There has been no reassignment by the Chief Judge to date. To the federal government of Nigeria, as long as Mazi remains in DSS custody, the trial can go to hell." Onyendu Mazi Nnamdi Kanu has since 23 December 2024 written to the Chief Judge of the Federal High Court for the reassignment of the case, but to date nothing has happened. On the part of the prosecution, no effort whatsoever is being made to reassign the case to another judge. We all know how many judges are in the Federal High Court, Abuja, who are eminently qualified and competent to hear the case on its merits. But it seems either Justice Binta hears the case or Mazi Nnamdi languishes in DSS detention indefinitely. Stay tuned for more updates, stay safe, and have a blessed day.